I request to keep your phones on silent or switch off and maintain the decorum and protocol since the guest is set category security. Please maintain the decorum and all the protocols. Thank you. Okay. Please remain silent. The guest is arriving. I request everyone to please rise as the guest has arrived. Good morning, one and all present here, respected chief guest, esteemed dignitaries, faculty members, students, and distinguished guests. It is my privilege and honor to welcome you all to this momentous occasion, The ninth edition of Mgr Gregorios Public Law Lecture Series, organized by Professor Dr. N.R. Madhav Menon, Chair on Legal Education. To commence the program, let us invoke the blessings of Almighty. I invite the college choir for the prayer song.
ലോകം മുഴുവൻ സുഖം പകരാനായി സ്നേഹദീപമേ മിഴി തുറക്കൂ. ലോകം മുഴുവൻ സുഖം പകരാനായി സ്നേഹദീപമേ മിഴി തുറക്കൂ. കഥന നിവാരണ കനിവിന്നുറവേ കാട്ടിൻ നടുവിൽ വഴി തെളിക്കൂ. ലോകം മുഴുവൻ സുഖം പകരാനായി സ്നേഹദീപമേ മിഴി തുറക്കൂ.
This college has been named Mgr Gregorios College of Law in commemoration of Archbishop Benedict Mgr Gregorios, a spiritual leader, a great linguist, an economist, an educationalist par excellence, and above all, a profound humanist who epitomized love and compassion. It is indeed an honor and a privilege that this college has been named after such a great and noble soul who embodied in himself the eternal element of dharma, the law. In commemoration of the legendary life and service of Archbishop Benedict Mgr Gregorios, the college has instituted Mgr Gregorios Public Law Lecture Series. The lecture series is a unique platform to reinforce public law in India, and this helps our students to imbibe a deeper knowledge and understanding of various areas in law. As Dr. B.R. Ambedkar once said, the Constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of age. The topic for today's lecture is the Supreme Court and the challenges to constitutional amendments, which indeed upholds the spirit of age. To formally welcome our gathering, I invite our principal, Dr. John P.C., to deliver the welcome address. Sir, please.
The president of the meeting, Father Advocate Joseph N. Manath, the guest of the day, Mr. Justice U. Lalit, dear friends and colleagues. First of all, I welcome you all to this 9th edition of Mgr Gregorios Public Law Lectures. Most Reverend Benedict Mgr Gregorios was the Archbishop of Mgr Catholic Church and an educationist and also a philanthropist. And this college is dedicated in his name. In order to commemorate the legendary service, the legacy of Mgr Gregorios, from 2015 onwards, we are organizing this public law lecture series. The first lecture was delivered by Dr. Cornelius Flinderman, Professor of Law, Utrecht University, Holland, and was a member of the Human Rights Commission of UN. Following Professor Flinderman, Justice Kurian Joseph of the Supreme Court, Dr. Jaswal, Vice Chancellor of National Law University, Delhi, and Dr. Ranbir Singh, Vice Chancellor of Nalsar, Justice Mohammad Mushtaq of Kerala High Court, then Justice Jodhimani of Madras High Court, Advocate Prashant Bhushan, Dr. Gudmund Eriksson. Such legal persons are delivered lectures in this series on various topics. Sir, this is one of our prestigious programs. My duty today is to welcome you all to this lecture series. First of all, I welcome the president of the meeting, Father Advocate Joseph N. Manath, wholeheartedly to this program. Today, we are privileged that the former Chief Justice of India, Justice Uday Umesh Lalit is with us for delivering this lecture on the topic, the Supreme Court and the challenges to the constitutional amendments. Justice Lalit was the 49th Chief Justice of India and the sixth lawyer who is elevated to the Supreme Court directly from the bar. And he was a senior advocate there, and he hails from a lawyer family from Solapur. Lawyer family means his father was a judge of the Bombay High Court, his grandfather was a lawyer, his wife is a lawyer, his son is a lawyer. It's a lawyer family. Then, and in order to recognize his service, the Supreme Court appointed him as a special prosecutor, amicus curiae in 2G spectrum case. And as a judge, he was part of the bench in different important cases, triple talaq case, then the Travancore royal family's authority to administer Padmanabhaswamy temple case, then Bhima Koregaon bail application, then a Jallikattu case, and so on. He was a member of the bench. He's a good non-criminal lawyer of India. When he accepted the invitation, I thought that he would talk in some areas of criminal law. It's a malafide intention of mine. Anyway, we are happy that Justice Lalit is with us today. Sir, on behalf of Mgr Gregorios College of Law and on behalf of the N.R. Madhav Menon Chair on Legal Education, I extend heartfelt welcome to you, sir. Then I welcome my colleagues, my friends, and professors from other colleges. And last but not least, my students. I welcome you all to this program. Thank you very much.
Thank you. Thank you, sir, for your graceful words. I welcome the Director, Father Advocate Joseph N. Manath, deliver the presidential address.
The center of attraction of the day, the former Chief Justice of India, Venerable Uday Umesh Lalit, the principal of the college, the academic advisor, invited guests, my dear colleagues and my dear friends. Many things has been said already on the chief guest of the day. And as it is already pointed out, this is an historic event, historic occasion, that a personality of the stature of the Chief Justice, a person who adorned the position of the Chief Justice of India, is attending a function in our college. We are extremely grateful to the magnanimity of the former CJI, Mr. U. Lalit. Last month, I visited him in his residence. He was so kind to receive me, and also he accepted our invitation, and he is with us today. As it is already pointed out, Mr. Justice Lalit is coming from a legal family, so to say. And he has got the rare fate of directly getting an elevation from the bar to the bench. And this event has been materialized with the help of Dr. Mr. Srijit, the Executive Dean of Jinda Global Law School, Delhi. And I place on record the valuable service and help that Dr. Srijit rendered for making this event happen. Archbishop Benedict Mgr Gregorios. The word Gregorios comes from the Greek word Gregorios, meaning watchful or vigilant. And many things has been already said on Mgr Gregorios, and he was the member of the National Integration Council of India, and a person approachable to each and every member of the society, starting from a small child up to the President of India. He was approachable, he was available for all of them. And whenever, during the long tenure of 41 years as the Archbishop of Trivandrum, whenever he was in office, political leaders and religious leaders were looking up to him to solve problems in the society. We really lack a personality like Mgr Gregorios today, when we see so many turbulations and difficulties which arise in the society. And Honorable Mr. Justice Uday Umesh Lalit is very dear to Malankara Catholic Church. Why? When he was the advocate, was practicing as an advocate in the Supreme Court, it was Uday Umesh Lalit who represented Marivanius College in the famous principal's case. So he's not an alien or he's very dear to, and the names Marivanius, Malankara Catholic Educational Society, all those things are very close to the heart of Honorable Justice UU Lalit. And something regarding the topic for the day, constitutional amendment is always a hot topic. We have already had 106 amendments to the Constitution. We all know whenever somebody asks about, or somebody is asked to speak a few words on the Constitution, the first sentence would be the lengthiest Constitution in the world. And in order to make the Constitution relevant to the changing times, the mechanism incorporated is amendments. And we have broadly 4 different periods. First period beginning from 1951 with the Shankari Prasad case, and which ended in 1967 with Golaknath's case. In the beginning, the general understanding was there is no scope for the amendment of the fundamental rights. The second period began with Golaknath's case and ended in 1973 with the famous Keshavananda Bharati case. And the third period began with Keshavananda's case and ended with the decision on 7th November 1975 with the Indira Nehru Gandhi versus Raj Narayan, or otherwise called the election case. So we are in the 4th period. And when I approached Honorable Justice to suggest a topic, it was the suggestion, spontaneous suggestion of Honorable Justice to speak on the challenges to the amendments of the Constitution. That itself is a very dynamic, very creative topic. I don't take much of your time. Once again, thanking Honorable Justice for being with us this morning, and also Honorable Justice will be inaugurating the second edition of Mgr Gregorios mooting competition in the afternoon, in which the father and head of the Mgr Catholic Church, Hon'ble Basilius Cardinal Clemis, the manager, patron, and founder of the college will be present, wholeheartedly thanking for the magnanimity and generosity Honorable Justice has shown to Mgr Gregorios College. I remain. Thank you.
Thank you, Father, for sharing your insights with us. Today, we are privileged with the presence of a distinguished personality, a legal luminary who has left an indelible mark on the judiciary which contrived the event a preeminent one, Justice Uday Umesh Lalit. He enrolled as an advocate in 1983 and practiced in High Court of Bombay. He shifted his practice to Delhi and later was designated as senior advocate in the Supreme Court in the year 2004. He was appointed as the judge of Supreme Court of India in 2014. Honorable Justice U. Lalit was appointed as the 49th Chief Justice of India in August 2022. With utmost respect, I now have the privilege of inviting the Honorable Chief Guest, Uday Umesh Lalit, to address the gathering on the topic, the Supreme Court and the challenges to constitutional amendments. Sir, please.
Father Joseph Venmanat, Professor Dr. John P.C., Professor Dr. Thomas Kutti, all the distinguished persons who are present here, the faculty members, and the students who are present in large number, ladies and gentlemen. What Father has said is absolutely right. I have a deep connection with this institution in the sense Malankara church institutions. I had appeared in number of matters, and that was one of the principal reasons why I accepted the invitation immediately and readily. Second part, post my retirement, I have been teaching in number of institutions. I take regular courses in law colleges, about 5 such law colleges, and Bombay IIT. So it's always an opportunity which I can never let go when it comes to be addressing the students, having interaction with students. And that's something which, yes, that was the second reason. Coming back to the introduction which was given, I must say that yes, I come from a family of lawyers. My grandfather started way back in a district court in Solapur, in one of the districts in Maharashtra, way back in 1920. And somehow we have a tradition that the wives in the family keep educating themselves after they get married. So therefore, my grandmother was the first lady doctor of Solapur. My father, of course, carried the same profession. So therefore, he's still a practicing lawyer. He's 92 years of age, and I am a very rare specimen where I have retired from the profession, but my previous generation is still in practice. When I did law, carrying the same tradition, my mother also did law along with me. So therefore, we did law together. My wife also became lawyer after marriage. So therefore, that's somehow, we have been actually on a completely different plane. And the practice of law is going on without any interruption. unbroken chain for last almost 103 years. Very well. Now coming back to the topic that has been suggested, and Father Venmanath actually put it very, very lucidly in 3 or 4 compartments. The first one starting from, say, Sankari Prasad right up to Golaknath. But just a brief introduction. Under 368, which is the power given under the Constitution for amendment of the Constitution, there is a special procedure which has been prescribed. It is twofold. Number one, when it comes to ordinary amendments to the Constitution, it requires 2/3 members of both the houses present and voting. Now, if your Lok Sabha has 540, it means 2/3 must be present there. Minimum 2/3 must be present and voting. And then go by the simple majority, which is 50% plus 1 from and amongst those who have voted. This is the normal way. The second, slightly a stricter way is that whenever you are thinking of amending certain provisions of the Constitution which are federal in character, that is to say, if you want to amend the legislative list, state legislative list, list 2, you require not only the first part, which is 2/3 of the members present and voting and going by majority, but you also require ratification by more than 50% of the states. So therefore, this is the twofold idea which is emanating from Article 368. Now in Sankari Prasad, which was the case decided way back in 1951, bench of 5 judges presided over by Justice Patanjali Sastry, the then Chief Justice. The first amendment was under challenge. What did first amendment bring in? First amendment inter alia brought in what is called 31A and 31B onto the statute book. We all know 19(1)(f) gave the right to property to an individual, which was a fundamental right. Under 31, of course, there could be acquisition of property or estates, but subject to payment of compensation, etc., etc. So right from Kameshwar Prasad Singh, the tussle between, if I may use the expression, legislature on one side and the judiciary on the other, has always been to strike a balance and say that if there is a right which inheres in an individual to have property right, and if you wish to take away that property by way of acquisition, you must give him money equivalent, because that's the only way that you can compensate him so that he can buy an alternate piece of land, property, or whatever he wishes to do in the walk of life that he has chosen. And that's the tussle which started. Now, mind you, when we got independence, there were large number of what is called jagirs, jagirdars, zamindars. So therefore, large extents of land were under the control of few individuals. In order to have an egalitarian society, naturally, the consequence would be that we would be taking over certain portions of that land so that the landless persons can be accommodated by giving those lands. And naturally, if you say that you must pay what is called market value, then where are the assets, where are the wherewithals, where are the coffers are completely empty? It is impossible to do that. So therefore came the idea by way of First Amendment 31A and 31B. That is to say, put the matters slightly beyond the control of or the monitoring of the court. So therefore 31A, 31B, and then consequently what is called 9th schedule was the idea which was brought in by the First Amendment. That if you put laws in 9th schedule, they will be beyond the pale of challenge before a court of law. Therefore, this amendment itself was challenged in Sankari Prasad. And the majority, or rather the unanimity of the view is Justice Patanjali Sastry saying, and what was the idea of challenge? That look at my 19(1)(f), right? It gives me right to retain property, to possess property, to have property, hold property. And you are making an inroad in that property. And what is the corresponding protection under Article 13? That any law, quote unquote law, which violates or which infringes my Part 3 right, to that extent will be declared to be void. So therefore, if the amendment also seeks to do the same thing, why can't I challenge the amendment on that ground that it becomes violative of my right under Part 3, and therefore 13 must be the prism through which you must actually see that. Justice Patanjali Sastry said that law, expression law appearing in Article 13 has to be given a meaning which is essentially what is your law enacted in accord with your legislative power. Supposing, for instance, we enact Factories Act or Negotiable Instruments Act. These are normal legislations which do not require 2/3 of the members present and voting. So therefore, constitutional amendment requires a different mechanism, and therefore, expression law appearing in Article 13 has to be given a meaning which will not sort of collide with the idea under 368. In effect, what? Any constitutional amendment would be beyond the purview of challenge in a court of law, because it will not be treated as law for the purposes of Article 13, and therefore challenge on the ground that my fundamental rights are getting violated can never be entertained by the court. So this was the logic which flowed from Sankari Prasad. First Amendment. Then what exactly would be available by way of challenge? Some legal scholars say that if 2/3 were not present, then perhaps you can say that. If ratification of more than 50% states was not there, you can still say that. Or if though the matter touched upon the federal character of the constitution by which you were seeking to amend, you never took the ratification from the state. So therefore, some such superficial grounds, but substantially whether the amendment itself is good, bad, valid, indifferent, you can never challenge. That was the logic in Sankari Prasad, which prevailed from 1951 right up to 1964, which is Sajjan Singh. In Sajjan Singh's 17th Amendment was sought to be challenged, by which certain enactments were introduced or put in 9th schedule. Therefore, they went beyond the pale of the challenge before a court of law. Now, interestingly, Sajjan Singh, again a constitution bench of 5 judges presided over by Justice Mgr Gregorios, the then Chief Justice. 3 of the judges, speaking through Justice Mgr Gregorios, said that we go by Sankari Prasad. That's the correct enunciation of law, and therefore there cannot be entertaining any challenge to 17th Amendment. Other 2 judges struck a slightly different chord. One of them, Hidayatullah, he said that as presently advised, I would consider that a deeper kind of, assessment and consideration is required whether Sankari Prasad is good law or not. So therefore, at this juncture, I will still go with Justice Gajendra Gadkar, but I reserve my some kind of, the reservations that perhaps I think this subject requires a deeper consideration. The fifth judge, Mudholkar, he for the first time said that, yes, amendment, yes, you can do away with everything, you can modify, you can change, you can add. But supposing in case you say something, you change the constitution completely, overhaul it, change the character of that constitution, which is discernible from the preamble and so many other things, will the court still be precluded? He relied upon one judgment of Pakistan Supreme Court and said that such ideas, that there is something called basic idea in the constitution or basic feature of the constitution, which must be completely beyond the pale of amending process. But he said that this particular legislation, which is 17th Amendment, we need not go into that issue. But he, for the first time, flagged what is called basic structure idea. That was in October 1964. There is another very interesting idea. Sometime in February or March 1965, a German jurist came to Banaras and gave a lecture, and he said something about basic features of the constitution. So there has been a debate between the legal scholars as to who is the father or the genesis of idea of basic structure. Is it Justice Mudholkar or is it the German jurist? I had an occasion to have a chat with the German Chief Justice. I said that we have lived by that basic structure doctrine. What is your condition? He said, nothing of the sort. We don't believe in any of these ideas. Anything and everything can be amended under the German constitution and German setup. Very well. So therefore, 64 marked what is called Sajjan Singh, where there appeared certain kind of bubbles of doubt. 1967, as Father rightly put it, Golaknath. Bench of 11 judges. And mind you, out of those 3 judges, two other judges who had concurred with Justice Gajendra Gadkar, one of them was Justice Vanshu. One who raised a doubt was Hidayatullah, and both of them were part of what is now the next judgment, which is Golaknath. In Golaknath, the lead judgment is by Justice Subbarao. The concurring view, opinion is expressed by Justice Hidayatullah. Vanshu completely dissenting, Bachawat, Ramaswamy, 3 judgments on the other side. They accepted what was projected in Sankari Prasad on behalf of the petitioner. That is to say, law, expression law in Article 13 must take within itself even the amendment to the Constitution. Which would then mean, logical sequitur, that your fundamental rights are so sort of, important. They have been given such position of preeminence that no amendment can violate your fundamental rights of a citizen. So whatever be the collective wisdom, even one single individual can defeat that collective wisdom. So therefore, what did Golaknath accept? By 6-5, that Article 13 expression law takes within its fold amendment to the Constitution, and therefore anything and every amendment can be challenged on the ground that it violates the fundamental rights of a citizen. So therefore, now the pendulum went completely in a different way by 6-5. Then logically they had to say, what happens to all these amendments up till now? Because those amendments which were there were right from First Amendment to 17th. 17th was under challenge in Sajjan Singh, and then thereafter also. So what do we do with all those amendments? So therefore, they developed what is called a concept which is prospective overruling. So whatever has happened, so many agricultural estates, somebody's possession must have been taken, those lands must have then been divided and the holdings must have changed hands. Hundreds of people must have been holding, there may have been subsequent transfers. If I invalidate the original transaction itself, what happens to the subsequent ones? So therefore, they decided and devised what is called the concept of prospective overruling, so that what they say is, we have now decided the principles. These principles will be applicable in future. So therefore, anything and everything which affects the fundamental right in future, you can challenge it on this ground. But whatever has happened up till now, please don't touch it. So therefore, this is what our Golaknath. And in Golaknath now, Hidayatullah accepts the very same idea. That is to say, 13 must be the governing kind of, principle. So in that bench of 11, Subbarao speaks for himself and four others. Four others. So therefore, he makes 5. And Hidayatullah plus 1, 6. So 6 on one side, saying Article 13 becomes your charter of every right. Vanchu is on the other side. So Vanchu accepts what Gajendra Gadkar had said earlier and toes the same line even in Golaknath. Golaknath is 67. Within 6 years, the occasion came to reconsider that. Well, by which time, if you accept in theory, then anything and everything, whatever you do to the constitution may at some stage or the other will touch upon somebody's fundamental rights. So then the occasion came in 73. So we had oscillated from what? One Sankari Prasad, no challenge. Another Golaknath, yes, everything under 13. Now Keshwanand Bharati sought a midway. The pendulum don't want to oscillate from one end to the other. And what was that midway? A bench of 13 by majority of 7-6. A very, very thin majority. They accepted Mr. Palkiwala's submissions, which in turn had the roots in what Justice Mudolkar had said and the German scholar had said. That there is something called a basic idea in the Constitution which becomes or which goes beyond the purview of amendment. You can do anything, any other amendments, but so long as you do not violate, you do not destruct what is called the basic idea of the Constitution, you may still go on with it. What are these basic features? Again, the judges are not unanimous on this. So the lead judgment is by Justice Sikri, Justice Hegde, Justice Grover, Justice Khanna, Justice Mukherjee, Justice P. Jagan Mohan Reddy. 6 of them, now 7th one, Shellot. Yes. The 6 of them on the other side were Justice A.N. Ray, Justice Palekar, Justice Chandrachud, Justice Matthew, Justice Dwivedi, and Justice Beg. So 6 of them on the other side. Very, very difficult to say what exactly are the basic features, because they become something like subject to individual perception. For instance, let's put it this way, that we believe in democratic ideal of the society. So therefore, democracy or democratic principle is part of your basic structure. Well, what kind of democracy? Parliamentary or presidential? Can we overhaul our constitution and say that hereafter we will be democratic country, but we will adopt what is called presidential model, which is prevalent in countries like United States of America? That's also a democratic country for last 250 years. Why can't we do that? Very well. There are certain observations saying that we have adopted parliamentary democracy as the principle. So therefore, one can say that, yes, that is your basic feature idea. Adult suffrage is your basic feature idea. So therefore, 18 plus. Or perhaps one can say initially it used to be 21 plus. Now it became 18 plus. Then periodic elections, so that the electorate gets a chance to review the conduct and the performance of their representatives. Can it be said that, this country cannot afford elections and so therefore it becomes a very costly affair? So let's put it this way, whatever be the parliament which gets returned to the power today shall be in power for next 20 years. You are having democratic principle, but you are not giving them periodic chances to see the performance of your representatives. So therefore, these are some of the ideas which you will get from individual judgments. Very difficult to say and pinpoint as to what exactly would be the basic features. But there are certain ideas which are there. Some of them are from Justice Sikri's judgment, and then some of them from the other judgments. You will see what exactly would be there. But what is normally accepted is that we believe in democratic principles, we believe in separation of powers of three institutions, and therefore there has to be what is called the power of judicature, which is preserved. So independence of judiciary, rule of law, etc., that is something which is part of your basic feature, doctrine or idea. So therefore 7 to 6. Keshwanand Bharati says Golaknath was wrongly decided. So therefore we bury the ghost of Golaknath. So what is now the idea? The idea is constitutional amendments. Parliament has the right, but only one rider or limitation. It should not violate basic features of the Constitution. Now hereafter, as Father rightly put it, so therefore now comes the acceptance of this as a doctrine and then application of that. Now the first case, as he rightly put it, Indira Nehru Gandhi versus Raj Narayan, decided in 76. So 73 is Keshwanand Bharati. Within 3 to 4 years, the Supreme Court had an occasion to consider the application of that doctrine. Now this time the bench is presided over by Chief Justice Chandrachud, the senior Chief Justice, who was the junior most judge in Keshwanand Bharati and who was in the Club of Six, which is in the minority. But he accepts that, yes, no, sorry, this bench was not presided over by Chief Justice Chandrachud, it was by A.N. Ray. Chandrachud was a party, A.N. Ray, M.H. Beg, Matthew, Chandrachud, and Khanna. These were the 5 judges. But the court then accepts the idea that yes, there has to be what is called application of basic feature doctrine. What had happened in this? After Indira Nehru Gandhi lost her election, there were certain amendments to the Constitution, including one very crucial amendment by which the elections to the offices of the Prime Minister, the Speaker, were kept beyond the normal challenge. And it was decided that it is only the House which will have the power and nobody else, no judicature, no intervention by anybody. It was that kind of provision in the Constitution which got inserted, was under challenge in Indira Nehru Gandhi, and for the first time we saw the application of what is called basic feature doctrine, and therefore saying that very well you cannot put the matter beyond the challenge of normal judicial wing. So even if it is Prime Minister, even if it is Speaker, his election as member of the House can still be governed by what is called the normal logic, and the courts will certainly be competent to enter into and see the matter. So the first application of Keshwanand Bharati was in Indira Nehru Gandhi in the year 1976. Then the next, Minerva Mills in 1980, by which time Justice Chandrachud is the Chief Justice, and I made a wrong mention. It is Chief Justice Chandrachud who is now presiding over Minerva Mills bench. Again, the matter was argued by Palkiwala. And one of the provisions of the Constitution, what happened is that by way of an amendment, 42nd Amendment, there is a provision in the Constitution which says that when you initially brought in 31A and B, what you said is that any law which is to give effect to the directive principles set out in 39B and C would be beyond the purview of challenge. They wanted to expand the scope of 39B and C and say that any law which seeks to give effect to any directive principle shall be beyond the purview of challenge. That part, saying that it will be beyond the purview of challenge, was the subject matter in Minerva Mills. Whether can such an amendment be brought in, whether will it be within the purview, within the powers of the parliament to come out with an amendment of that nature. And that was one of the subjects inter alia which Minerva Mills accepted and said that sorry, you cannot do that. So the second judgment, which is Indira Nehru Gandhi, the second one is Minerva Mills, where the challenge to the constitutional amendment got accepted by the Supreme Court. Then the third judgment. In fact, there are two judgments which were delivered around the same time because the composition of the bench was identical. The bench presided over by Chief Justice Bhagwati. One in Sambamurthy, where Chief Justice Bhagwati himself was the author of the judgment. And the very same combination, another judgment which was Sampath Kumar, which was decided by Justice Ranganath Mishra as the lead judgment, Bhagwati supplementing that. The other members of the bench were Justice, I think, M.M. Dutt, Khalid, and somebody else. I don't recollect the fifth name. So 5 judges, same thing. What happened in Sampath Kumar? Number one, by virtue of power, which was, I think, under 42nd Amendment, 323A, idea got sort of germinated in our constitution. That is to say, there can be administrative tribunals for certain specific subjects. And one of them was service jurisprudence issues. Like, for instance, whether a person is entitled to be promoted or not, whether the seat has to be reserved for promotees or for the direct recruits, what shall be the reservation in proportion, whether is it quota, whether it is rota. All these kinds of issues, service jurisprudence matters, can be given to administrative tribunals, and it therefore enabled the parliament to come out with any enactment touching upon administrative tribunals. One provision in that was that we don't want duplicity of challenges and matters, and therefore we will create an exclusive jurisdiction on issues such as service jurisprudence in a body called Central Administrative Tribunal. So creation of exclusive jurisdiction, and secondly, bar of jurisdiction by other courts except the Supreme Court in appellate power. So therefore no other court shall touch upon that. So therefore this very amendment was subject matter of challenge in Sampath Kumar. And the idea which weighed with the court was It is true that yes, judicial review is part of your basic feature of the constitution as decided from Keshwanand Bharati down the line. But are we dispensing with judicial review? We are simply, instead of High Court, we are giving this power to the Central Administrative Tribunal. So we create what is called an alternative institutional mechanism. And the moment we create that, it should not be taken as if citizens are deprived of any scope of challenge. So therefore, there is nothing wrong in that. And therefore, Central Administrative Tribunal can effectively function as an alternative institutional mechanism. You can still challenge the decisions of Central Administrative Tribunal before the Supreme Court. So there will be one rung of challenge which is still available to you. High Court, of course, gone. This was the logic which weighed with Sampath Kumar. Around the same time, because Justice Bhagwati retired sometime in 26th of December, these are judgments of December 1986. So around the same month when Justice Bhagwati was to retire. So Sampath Kumar decided, now the turn of Sambamurthy. What was the idea in Sambamurthy? In Sambamurthy, again, creation of similar kind of administrative tribunals. But these were under 371D, that is special provisions for some of the states. And here the state in question was Andhra. And the constitution said, the amendment to the constitution, which was brought in by, I think, 32nd Amendment, it came out with two ideas. Same, creating an alternative institutional mechanism in the form of a tribunal. So therefore, Justice Bhagwati, who was the author of Sambamurthy, said, oh, we have already decided that in Sampath Kumar. So alternative institutional mechanism as a principle we have accepted. So therefore, this challenge perishes. But there was one more challenge. And the challenge was that the decisions of such administrative tribunal by virtue of the constitutional amendment would be subject to acceptance by the executive. That is, if the tribunal were to say that so and so percentage of people in this service must belong to a particular community or must go by promotion, that's the determination by the tribunal. Such a determination by the tribunal would be subject to acceptance by the executive. The executive may accept it, may not accept it. This, Justice Bhagwati said, is a very, very serious kind of, flaw in the entirety of the matter. This is unconscionable, this is unthinkable, that a determination by a judicial body is subject to the acceptance by the executive. This will be direct invasion so far as the idea of rule of law and independence of judiciary is concerned, which are basic features of the constitution. So the very same combination of 5 in Sambamurthy held the constitutional amendment to be invalid. In the same month, December, Sampath Kumar and this Sambamurthy. So therefore, the third successful challenge was in the form of Sambamurthy. The fourth, which was Sampath Kumar, got remedied sometime in 97 when Chief Justice Ahmadi, 94 perhaps, 97. When Chief Justice Ahmadi was presiding over a bench of 7 judges, which upset Sampath Kumar and said that the entire idea by which you are displacing the courts under the constitution, that is the High Court, is not acceptable. So therefore, independence of judiciary is not just the Supreme Court, even the High Courts in the country. And the moment you try to bypass screening by the High Court, you are making inroads in that basic feature of the Constitution, and therefore such an amendment must be declared to be void. So Sampath Kumar, though initially in 86 accepted it, finally got buried as a result of Chandra Kumar. Now, very interesting thing, for law students, how did Chandra Kumar begin? After Sampath Kumar, a division bench of the High Court in Andhra, Justice M.N. Rao presiding, had an occasion to consider one of the submissions which was advanced was, if according to the decided cases, including Keshwanand Bharti, independence of judiciary and judicial review are the basic features of the constitution, how could High Court be displaced? And to the extent that the Sampath Kumar accepted that, Sampath Kumar itself be declared to be per incurium. And the bench accepted that. So we had a very, very peculiar situation where a constitution bench decision on the validity of a constitutional amendment had said that the amendment is perfect, yet a division bench of the High Court went to the extent of saying that that constitution bench itself, the decision is per incurium. And that is how the matter came up before the Supreme Court in the form of Chandra Kumar. If any of you are interested, you should read that Chandra Kumar extensively, portion after portion coming from that division bench judgment of the High Court of Andhra are copiously quoted in Chandra Kumar. But Chandra Kumar then accepted what division bench of Andhra had said. And therefore, Sampath Kumar was held to be wrongly decided, and the constitutional amendment was to that extent declared to be incorrect, invalid, and void. So we have now how many? Indira Gandhi, Minerva Mills, Sambamurthy, and Sampath Kumar, quote or slash Chandra Kumar. This is in 97. In the meantime, in 94, Justice Venkatachalaya presiding, there had been, I think, 52nd Amendment to the Constitution by which 10th schedule got inserted in the Constitution. 10th schedule, as everybody is aware, 10th schedule brought in what is called anti-defection laws, or the idea that a person who gets elected under one party in certain situations and subject to certain ideas cannot be allowed to vote against the directions issued by that political party or the whip of that political party. In case he does, he incurs disqualification. Who decides that he has incurred disqualification? So the chairperson of the House, if it happens to be Rajya Sabha chairperson, if it happens to be Lok Sabha speaker in state legislature, speakers of the House, etc., etc. After the speaker decides what? So the constitutional amendment para 7 of that 10th schedule said that the decision of the speaker shall be final and shall not be called in question in any court. Again, the antennas get raised. How can you say that? That it is beyond the challenge. Judicial review is part of our basic structure. Independence of judiciary is part of our basic structure. So therefore, how can this be that the speaker becomes the ultimate voice? So therefore, challenge can still be entertained. And to that extent, the amendment is incorrect and invalid. So therefore, the 5th determination comes in what is called Kihoto Holohan, which is a constitution bench judgment by Justice Venkatachalaya, which was on the validity of 10th schedule to the constitution. This is in 94, 97 comes Chandra Kumar. And then we have one more decision of the court, which is in what is called NJAC, which came in 2015. I was appointed as a judge of the Supreme Court on 13th of August 2014, and on the very same day, this amendment was brought in. So amongst my brother judges, that used to be the scenario that perhaps you are the last appointee by the collegium. But yes, now leave aside the lighter side of it. But so therefore, again, the challenge, what did NJAC law bring in? What is called 99th Amendment to the Constitution. It brought in a concept such as National Judicial Appointments Commission. A specific article was brought in which is called 124 capital A, and consequential amendments to 124 and 217 which deal with the appointment of judges of the Supreme Court and the High Court respectively. What was the earlier status? The earlier status so far as 124 was concerned, it empowered the president to make appointments of the judges of the Supreme Court in consultation, mark that expression, in consultation with the Chief Justice of India and such judges of the High Court and the Supreme Court as the President may deem appropriate. So three consultee kind of, chambers. Number one, Chief Justice of India, judges of the Supreme Court, and even judges of the High Court. So three areas to be consulted. Up to the President, what he wishes is a different thing. And then thereafter make an appointment of a judge of the Supreme Court. Now come back to the mirror image under 217 when it comes to appointments of the judges of the High Court. Again, in consultation with the Chief Justice of India and Governor of the state and Chief Justice of the High Court, to which an appointment is to be made if the appointment is concerning a judge other than the Chief Justice. So again, three areas of consultee quarters, if I may use that expression. Governor of the state, which means the executive of the state, Chief Justice of the state, High Court, concerned High Court, when it comes to appointments of normal judges. But when it is naturally Chief Justice, you can't consult him. Therefore, Chief Justice of India in any case is there. This used to be the regime before 99th Amendment. Now we come to the interpretative process of this very regime. In S.P. Gupta, a bench of 7 judges held that expression in consultation does not mean in concurrence, which means Chief Justice may say, suggest one name. That does not mean that the opinion of the Chief Justice is binding to such an extent that you must make that appointment. Or if he says, sorry, don't appoint him, you must actually weigh in whatever his opinion has been. So therefore, this was the logic. Then came 3 judgments of the Supreme Court. And we then devised what is called, first and foremost, we said in consultation would mean in concurrence. Number 2, we don't want the office and the person of the Chief Justice alone to be the deciding factor. There must be some democratization. And so therefore, at the Supreme Court level, let there be a club of first 5 judges, including the Chief Justice, which is hereafter to be called as collegium. The collegium will make a recommendation, and going by such recommendation, which will then be binding on the executive in certain ideas. Therefore, they may have, supposing, for instance, the profile of that man, that he appears to be a complete debauch, he appears to be somebody who has secreted away money, he appears to be somebody who is guilty of PMLA offense, or some such thing, if it is there, which perhaps the collegium may not be aware, and that kind of an input is forthcoming from the executive, the executive may be justified in sending back the proposal. But the moment the proposal is reiterated, it becomes binding on the executive to make the appointment accordingly. This is so far as Supreme Court. What about High Court? Again, the same idea, because your article said in consultation with the Chief Justice. So again, we expand the scope. Instead of one single person, we say numbers 1, 2, 3 in the High Court. So what is called the High Court Collegium. The governor would mean executive. So therefore, executive will also put in what is called their inputs. And then the matter will finally be decided by the Supreme Court Collegium and then further up. This entire idea was sought to be dispensed with by 99th Amendment, and what it brought in was National Judicial Appointments Commission, the composition of which was, number 1, Chief Justice of India, 2 other members, that is judges 2 and 3 in the Supreme Court, law minister, number 4, and 2 jurists, legal kind of, jurists in the matter, one of whom must be either coming from minorities or scheduled caste, scheduled tribe, or some of the disadvantaged sections of the community. So therefore, 6-member National Judicial Appointments Commission, which will hereafter make recommendations so far as appointment, transfer, everything pertaining to the judges of the High Court and judges of the Supreme Court. Which in effect meant, when it comes to making recommendations as judges of the High Court, governor gets displaced, Chief Justice of the High Court gets displaced completely. So therefore, at the state level, none of the apparatus at the state level had any say in the matter. It will be only at the commission level, which will be law minister, 3 judges of the Supreme Court, and 2 legal jurists. Theoretically, let's just by way of argument, just consider. If the legal jurist happen to be somebody who have been brought up in Supreme Court all the while, how much do they know about, High Court of Kerala, or High Court of Andhra, or High Court of Manipur, Meghalaya? Who are the persons who practice there? So the initial idea that Chief Justice and the governor would be given some kind of say in the matter got completely displaced. Very well. The challenge came up before a bench of 5 judges presided over by Justice Kehar, and by a majority of 4-1, the judges came out with the idea, and their principles are very, very, may appear to be slightly an extended logic, and deliberately sort of, logic which sort of gets elasticity getting sort of, stretched every time. What is the logic? Independence of judiciary is the basic feature. How will you ensure independence of judiciary? By having good quality independent judges. So the second step, how will you select independent judges? By somebody who has that wherewithal to judge the ability, judge the merit, judge the mettle, judge the capacity. Who are best suited? The collegium and the judges. What have you now done? In a body of 6, there are only 3 judicial members. Other 3 are not strictly coming from judiciary. So therefore, the weightage which ought to be to the judicial organ gets completely diluted. And therefore, this amendment is not on the right side of law. To certain people, this appears to be very, very stretched logic. But it weighed with 4 out of 5 judges. Justice Chalameshwar dissenting. The other 4 judges, Kheher, Madan Lokur, then Kurian Joseph, and Justice Goyal. They accepted it. And therefore, the one more example where the amendment perished as a result of this is your NJAC 99th amendment. So up till now, I have covered where perhaps I think the response by the Supreme Court to some of the constitutional amendments saying that, sorry, red flagging it, or turning down, or saying, sorry, you cannot go beyond this. These are some of the examples. There are, of course, umpteen number of examples on the other side where the courts have accepted the amendments. But if you see that where they have not accepted, the common thread which runs through that are either rule of law, independence of judiciary, or judicial review, which means starting from Indira Nehru, then Minerva Mills, then Sambamurthy, then Sampath Kumar, then your NJSC, Holohan. Every time it is either this compartment. So is it that the Supreme Court has refused to look into any other compartment, which may also be basic feature doctrine? And there are 2 cases, interesting cases, which let us now consider. Number 1, when Sikkim got, I won't say annexed to the Union, Sikkim became part of Union volitionally. So therefore, when Sikkim became part of the country, admission of that particular region as a state under the Union came by way of an amendment. I think 34th and 35th, 2 amendments. And Sikkim used to have a very peculiar ideas. It is a hill state where there is a lot of Buddhist monks are there. And those monks belong to various denominations or religious orders. And they call them as Sangha. So in the Legislative Assembly, when Chogyal was the person in charge in Sikkim, there used to be representation to Sangha in the Legislative Assembly. And that very representation got carried by way of amendment to the Indian Constitution. So therefore, in a body which is legislature of Sikkim, there will be 1 seat which is reserved for Sangha. It was challenged in, amendment itself was challenged, but one of these ground was challenged in a case called R.C. Podial versus Union of India, 5 judges bench, presided over by Justice L.M. Sharma. And L.M. Sharma is the lone dissenting voice. Other 4 judges are on the other side. According to Sharma, if we as a country, we believe in the ideal that the country or the state has no religion, the religion has no place in public affairs. It's a matter of individual kind of, the belief. We will definitely allow every individual to preach, propagate, and profess any religion, but the state will not do any such thing. And how do we accept the fact that in legislature, 1 seat can be reserved for Sangha, which is purely on religious ground? So therefore, such an idea flies directly in the face of what is your basic feature doctrine, which is that the state will not be having any religion. We are a secular country. And secularism is definitely part of your basic feature. So therefore, such a provision in the Constitution would be invalid. But the other 4 judges do not accept that. So therefore, we had a very beautiful, kind of situation where the Chief Justice presiding over the bench was in minority. It happened in Triple Talaq when Chief Justice Kheher was in a minority. It happened with me when EWS judgment was delivered. I, along with Justice Bhatt, we were in minority. And it happened with Chief Justice D.Y. Chandrachud when same-sex issue came up. he was also in minority. So therefore, there have been some of these cases where the Chief Justice himself is in minority. So therefore, one challenge got rejected. I'm just placing something apart from what is normally judicial review, rule of law, independence of judiciary, something beyond that. What is normally considered to be a basic feature of the Constitution. Then comes EWS, where 103rd Amendment was under challenge before the court. And what did that amendment say? It brought in two ideas in 15 and 16. Number one, apart from reservation, which is traditionally granted to scheduled caste, scheduled tribe, and after Mandal to OBCs, now a fourth vertical can be added, which is EWS, economically weaker sections belonging to communities other than these three. And there can be reservation up to 10%. That was challenged, saying that this goes against the very idea of Constitution. Constitution does not acknowledge a class of beneficiaries such as people coming even from forward communities. Because the moment you say not for any of these three, which would mean they are forward communities. Because what you have actually described is scheduled caste, scheduled tribe, and other backward communities. So therefore, who doesn't belong to these three communities will naturally be the forward community. So therefore, according to our constitution, this goes against the ethos of the constitution that there can be reservation for communities other than scheduled caste, scheduled tribe, and OBCs. This was accepted by the minority, Justice Ravindra Bhatt and I, but the majority did not accept it. They said it's a perfectly valid, good constitutional amendment. So therefore, two examples which I've presented before you are those which are completely outside the package of what is called judicial review, rule of law, independence of judiciary, something connected with judicature, something outside that. Otherwise, you will find every single accepted challenge pertains to this chamber. So therefore, these two cases, there have been cases like Nagaraj, for instance. Nagaraj was a case decided by Chief Justice Kapadia that whether in promotion can you grant consequential seniority, etc., these issues. So all those constitutional amendments were held to be valid, but unanimously. There's not a single note of dissent anywhere. This is the broad spectrum of the cases decided by the Supreme Court and how the challenges were always considered by the Supreme Court. Now, I'll give you one classic case, which is a reverse case. In 1993, Unnikrishnan was decided by a constitution bench of the Supreme Court. And the majority decision was two judges refused to note anything on the point. Three of them. What did they decide? They said, if Maneka Gandhi says that your right to life is not just mere animal existence, but is a right which inheres in every individual to reach the optimum level or the best possible levels of his development, his or her individual development. That's the way you treat life, a meaningful existence, not just animal existence. Then, if you accept this as a proposition, how would you reach the maximum levels of your potential minus the education? And therefore, we hold that every child in this country in the ages of 6 to 14 will have a fundamental right to be educated, to be imparted education, free, compulsory, and good quality education. Now, this is by way of interpretative process. What you say is, this is part of somebody's fundamental right. 93 comes the decision. Parliament steps in 2002, 9 years thereafter. They don't try to water down the effect of Unni Krishnan. They accept Unni Krishnan and make the consequential amendment to the constitution and bring in what is called 21 capital A. So it now gets the constitutional status. I have seen very few examples where whatever has been decided by the Supreme Court. Take for instance, this very case, Indira Sani. Indira Sani said, no reservation in promotion. What came the odd constitutional amendment? Some of the decisions said, very well, promotion, yes, but not consequential promotion. Again came the amendment. So therefore, Inamdar said that very well, in private institutions, there can't be reservation getting work. Comes the amendment, gives the enabling power. So therefore, you will see that courts, when they say something, the parliament steps in and says otherwise. But here, the parliament didn't say anything otherwise. It accepted the logic which flows from Unni Krishnan. Of course, it took them 9 years. Why? Because the moment you say it is right of every child, you need to give that. Where is the infrastructure? Where is the wherewithal? Where are the finances? Where are the teachers? Where are the schools? So they were trying to equip themselves with everything for next 9 years, trying to see what kind of budget, what kind of allocation. But then finally it saw the light of the day and 21 capital A gets introduced. I actually say that if you say judicial activism, perhaps Unni Krishnan was at the highest level. That you're not even saying something, you say every child in this country must be educated. Look at the spectrum, look at the width of that direction. It applied to every child in this country. And that's the judicial activism at the highest, where the parliament also accepted the fact that yes, this is the correct way of understanding. And that's where you have this. So what have we seen from 1950 onwards? Tussle between right to property in 191F, 31, 31A, B, C, 9th schedule. Every time there had been attempt on part of the parliament to keep the matter beyond the purview of challenge by the Supreme Court. The Supreme Court intervened and cut it short. This is perhaps, I think, the sum and substance of that idea. So we saw the pendulum, Sankari Prasad, no challenge. Hidayatullah, in what? Golaknath, everything can be challenged. 13 becomes your idea. Now we are settled very carefully and clearly. Mind you, this basic structure doctrine, we are the only country which goes by that, which is so sort of, evolved, so sort of perfected, so sort of, has taken the roots in this country, that it is something that we as students of law, we are proud of that, and we will always cherish that particular idea. This journey has seen 44th Amendment saw us what? Right to property getting out of Part 3. So over last almost 75 years, we have seen one right getting lost, getting out of Part 3, but one right getting into the Part 3 right, which is 21 capital A. That perhaps is the journey of what? 75 years of constitutional amendments and the responses by the court. Thank you for listening to me patiently. Thank you so much.
Thank you, sir, for that intriguing and exceptional speech with every minor details on the topic. Now the floor is open for an interactive session. You may raise your questions.
there will always be some starting trouble. Somebody said there should be there to start. So I'm very happy to sit alongside a person who delivered the EWS judgment, a part of the bench. I have a question. Many a time, the Supreme Court decided several cases, and the Supreme Court was so particular in having the evidence for making a particular decision. But in the case of EWS, there was no such strictness for having the evidence before the court. It is a layman's feeling. What is your lordship's response for that?
See, what was presented before us was the text of 15.6, 16.6, which empowers the Parliament to come out with amendment or sort of make a provision for the advancement of EWS as a category. What is that EWS? Is not determined under the Constitution. It is only an enabling power given to the state. Some of the states who have come out with the idea is that if the family income is less than 8 lakhs, if the holding of land is something less than 3 acres, 5 acres, or so on and so forth. So some of the parameters are laid down, and any family income or any family assets are less than that, they will be taken to be EWS, that is economically weaker section. I must also tell you that one of the frontline attacks in that judgment was on this issue. It said, look at scheduled castes, look at scheduled tribe, OBC, or any such reservation. It is a permanent kind of feature which is part of that personality of that person. Whether he likes it or not, he is scheduled caste. Whether she likes it or not, she may be scheduled tribe. So therefore, it becomes part of the persona, whatever be the rise, whatever be the fall, whatever be the movement of that individual in the society. So it's a characteristic which is permanent, discernible. So you can discern that. If I'm masquerading my title, that I am belonging to scheduled caste or scheduled tribe community, there are scrutiny committees in the state at every juncture. So therefore they can look into that and accept or assess the claim. But EWS by very nature is a fluctuating phenomenon. A family today may be above EWS idea. Something wrong happens to the business of the member of the family or the head of the family, and the fortunes nosedive, and suddenly it becomes EWS. And the example which was given to us was, look at Pandavas. In one single day, they turned paupers. So therefore, can you say that they were now EWS? Economically weaker sections. So therefore, it's a fluctuating idea which is very, very difficult to judge and gauge. You may have situations in the society hereafter that the moment my child enters 11th, 12th, my income starts nosediving. Moment he gets admission in medical engineering, I again regain the same status in life. Very, very difficult, very, very subjective, very fluctuating, very impossible by very nature to actually translate it in reality. And that is exactly what Father said, that facts, where are those facts? Very, very difficult. But as a concept, it has been accepted. So therefore, what it now actually boils down to is that the implementation has to be very, very strict. If the implementation is strict, at least 1/4 of the society which deserves that kind of affirmative action will certainly have the benefit of that. Yes.
Hello, good morning. Thank you for the wonderful speech. My question is regarding referendums. We see many European countries having referendums regarding matters that directly affect the public. In India, we don't have such a case. Is it because of the population, the just large complexity of billions of people living in a very small country? Why don't we have referendum in the constitution? That's my question.
See, I had a discussion on this very issue with one of the scholars coming from Australia, New South Wales University. In the Australian constitution, there is a provision of referendum and through which the constitution can get amended. So I asked him, how many times have you actually successfully had this kind of referendum as an idea to amend the constitution? He said it has become completely cumbersome. Because what happens is every single vote has to be taken into account. Correct. And by very nature, on a topic, wherever the European countries, the population has been under control. Some of the advanced countries where the growth of population is actually below 1%. So they are on the negative side. Whereas we were, say, 55 crores in 47, we are now 140 crores. Correct. So therefore, it's a population which is rising. It is extremely difficult to have referendum as a principle for amendment of the constitution. Secondly, that was not thought of as a relevant and a good idea by our founding fathers. Now, if you make an amendment to 368 to put in referendum as a principle for amendment, perhaps I think somebody may challenge it on the ground that it violates now the basic structure of the constitution. Okay. So therefore, very difficult, very cumbersome. Though in theory what you say is right. See, ultimately what was Ram Rajya? Even one single voice of that dhobi, that washerman, was enough for Raja Ramchandra to get sort of, to banish his wife, his own wife, to the woods. So therefore, that's the ultimate level, correct? Even one single vote can actually influence a executive action. But very difficult to practice and very, very sort of cumbersome in areas where it is actually part of their constitution. So the experience hasn't been so fruitful and so sort of, acceptable evidence. Yes.
Thank you, sir. Sir, my question is, sir, if any pressure or political interference, as you are in as a Chief Justice in India, is affecting for deciding if any case, your personal experience in as a Supreme Court judge of the post, please say, sir, your personal experience.
I can't say about others. On a personal note, there hasn't even been a single attempt to put any kind of, pressure on me on any aspect, whether it is administrative, whether it is judicial, whether it is something connected with the office at any juncture. Okay.
I have another question. See, actually, I have read more than 100 important judgments, including Ashok Kumar Thakur case. I have to be honest, I didn't attempt Keshavananda Bharati because of the length. But my question is, many parts of a judgment is it just look like a PhD thesis. So in this constraints or in the busy schedule of a judge, how come these long judgments be written? What is the mechanism for that?
Again, very, very difficult to say so far as the other judges are concerned. I can put it only when it is my personal view and personal ideas are there. I have always considered that a judgment must deal with the controversy, and to the extent that it requires, you must be clear about what is the principle of law to be applied. On a personal note, I have never accepted that you must quote right from first judgment to the last judgment in support of your idea what the statement of law is. You can quote last one or two judgments. If there doesn't appear to be clarity in that, you can quote a judgment in the mid level of the stream, but can't quote right from one to the last. I call it what is called quotational jurisprudence. So therefore, start quoting right from the first to the last and then say that this is what the situation is. But at times, the judges, perhaps I don't know the reason, what weighs with them, but they want to be very, very clear, very specific, so that any student who reads that judgment need not read anything earlier as well. So therefore, that perhaps could be the idea. Yes. Yes.
Thank you for a wonderful oratorical skill and wonderful speech. My question is there any difference between the amending powers of the parliament and ordinary legislative powers? That is, ordinary legislative powers of the parliament can be done with the ordinary majority, but this can only by two-third majority. And we have to remember the fact when the first constitution was made by the Constituent Assembly, the articles were included by a simple majority. Then why did we make this so cumbersome?
Now the idea is what you say is right, that it was done by simple majority by the Constituent Assembly. So why not by the same logic? But mind you, 1946, when the Constituent Assembly was put in place, India was a combination of many kind of, political apparatus in the country. There used to be large parts of what is called British India. The major representation to the Constituent Assembly came from what is called the area which is British India, provinces and other things. There were also Indian states like your own Travancore, Cochin, Mysore, Baroda, Hyderabad, so on and so forth. There were large kind of, area which was Indian states as well. So therefore, if we were to go by the same logic as we have now adopted in 368 and say that very well, why did you not have Constituent Assembly going by the same logic? It would have been completely impossible for them to go ahead with the process and then devise something for us. So therefore, it is always taken that, whatever has happened at the earlier stage, once you have accepted a document and that document becomes the governing idea for the administration, for the governance, then we must go by that. Now, coming back to your first part of the question, this is exactly what Sankari Prasad, Justice Patanjali Sastri, actually sort of, toyed with this idea. Now, imagine if you say that my constituent power exercise is different from my municipal or legislative power exercise. Then naturally you will have one area through which your legislative exercise must pass through as a filter is your Article 13. So therefore, everything must be in conformity with my fundamental rights. Correct? Now, the very idea of your constitutional amendments, the fact that you came out with something called 31AB, the fact that you came out with 9th schedule as a principle, you put the matters beyond the purview of the challenge before the court. You don't want that prism or the filter of 13 to get applicable to constitutional amendments. So therefore, you yourself are treating, leave aside the kind of majority which is required for passing the legislation, whether it is municipal legislation or constituent exercise legislation. But leave aside that, at least at that level, you would still require that, and therefore you made a distinction. Now that distinction was sought to be obliterated in Golaknath, saying that nothing, everything must go through the filter of 13. The moment Keshwanand Bharti says Golaknath was wrongly decided, which means that that logic that there is only one filter of Article 13 is not a correct logic. Therefore, you accept a dichotomy or two principle idea when it comes to your normal legislative power exercise and constituent power of exercise. Correct. So therefore, this is where you go. And then now you have actually sought some kind of a midway between two extremes and said that very well, if it doesn't affect the basic structure, we will still accept that as a logic. Correct? So therefore you do that. Now take for instance the reverse way. I gave you the example of Sikkim. Supposing if by way of a normal legislative exercise, if one seat was added in your Kerala Legislative Assembly, what would be your response? You would say, sorry, what kind of nonsense is this? Correct? This legislation needs to be struck down. On what? Because it violates what is called the basic sort of, fundamental rights of the citizens. But it was a constitutional amendment. So they accepted the logic that, there can still be a reservation of one seat for Sangha. So therefore, in our jurisprudence, we have always considered these two streams to be slightly different, though running parallel to each other, but they still maintain a distance between them.
Sir, good morning. Sir, first of all, thank you for this amazing lecture. Sir, my question is, in the NJAC case, the Supreme Court held the National Judicial Appointments Commission to be unconstitutional. But as per the principles of natural justice, no man shall be a judge in his own case. So isn't that contradictory?
Then who should decide? If you ask me, then, who should decide? Supposing no man, a person cannot be judge in his own cause. Very well. Correct? So then who should decide then? You give me the alternative idea. There is no alternative. So therefore, again, as a principle of administrative law, there is an element of necessity, doctrine of necessity. So who else can do that? Again, the same, flip side to this argument. None of those 5 persons were expecting any kind of appointment thereafter. So they had no interest in the matter. One can understand somebody aspiring to be a judge and he is now part of the bench. But there was no aspiration of that level. They had already reached the Supreme Court. Nobody could throw them out of the Supreme Court. So there was no element of what is called the interest in the matter in that sense. Okay?
Thank you.
So, good morning, sir. Myself, Brahma, final year LLB student. So, my question is, there is a recent judgment regarding the subcategorization of the SC/ST reservation. So, do you think it's kind of, in one way, injustice to the general category, even that subclassification of SC/ST reservation?
That again is a matter of, a very debatable issue. If you go by 341, 342, what does it say? It says that the initial determination as to which communities are scheduled caste in respect of a state or a territory shall initially be determined by the president after consulting the governor, etc., etc. And then thereafter, power to add to, modify, delete, etc. is given to the parliament. Now take for instance, there is one community which got added. And the anthropological now survey and analysis actually shows that that community is quite advanced. It doesn't require the kind of affirmative action by putting that community in the list of scheduled caste in respect to a state. Supposing if the parliament amends and throws out that community from the list, it's a perfectly valid exercise in accord with the constitution. Correct? Accepted? Now, this very logic was actually present in that Rangaya matter. That supposing in a state there are 25 different communities which are, say, scheduled caste or scheduled tribe. Can you say that, oh, out of these 25, 5 are very, very advanced? So therefore, out of my reservation of 15%, I will give them chance of window only to 3% out of 15. But rest of the communities can have chance with respect to everything. So what you then do is you do a classification within that classification or subclassification. Perhaps the exercise could be the fact that you come to a conclusion that these 5 communities do not require so much of affirmative action. Then the best possible exercise would be to delete them by taking resort to 341, 342 principle. That's also possible. But then that can be done only by the parliament. Whereas subclassification at the state level can be taken resort to by individual states. And perhaps they therefore find it very, very easy resort or easy mechanism to adopt. Now in Rangaya, Justice Hegde's judgment, they said that such kind of classification, not Rangaya, Chinnaya. So they said that, sorry, it cannot be done. Now that very judgment is now actually sort of, getting reviewed as a result of that. We'll have to wait and see what actually emerges out of that. Okay. I have no difficulty. I have no other immediate.
Sir, sir, I have a very different question. If the question is not connected with the topic of the day, kindly excuse me, sir. The question is this: in the context of the nexus between nexus between the executive and judiciary, in the parliament, there was a statement at a point of time. The pre-retirement judgments will be influenced by the post-retirement positions. So this was the statement raised in the parliament. They wanted the answer from the authority also. The same doubt is there, the question is there in the minds of the laymen like me, sir, as a student and layman like us. So what is your response to this question, this statement, sir?
These are very catchy phrases, Pre-retirement judgments getting influenced by post-retirement kind of SOPs that a person expects. These are very, very difficult ways of considering the matter. What has happened is that today, of course, yes, as a society, we must be vigilant. So therefore, everything has to pass the scrutiny of the eyes of the people, correct? No doubt about it. But you must realize that a judgment given by the Supreme Court is always a bench decision, is never the judgment of a single individual. Even if it is pre-retirement, it is a judgment which is endorsed by the brother and the sister judges. So it is not the judgment of that individual. It is a judgment of the court. When you say pre-judgment or pre-retirement judgment, you are actually accusing the brother and sister judges to be so gullible that they can get influenced by the prospects of post-retirement prospects of their brother or sister judges. Are you not saying something about the independence of those individuals? They are not expecting any retirement at that juncture. So therefore, what happens is we get influenced by these catchy phrases. In reality, it can never happen, sir. There are, otherwise you won't have so many dissenting notes which comes day in and day out. What did Justice Dipankar Datta say? What did Justice Nagaratna say? In some of the recent judgments. So therefore, always consider that the judgment is always judgment of the court. Please don't attack it at an individual level. Okay.
So my question is with regard to the habeas corpus, Keshavananda Bharati case. A lot of people are clamoring about it, but my primary doubts are, the case was decided by a 13-member bench, as you know, to a 6-7 majority. Each judge wrote a different opinion, and each of them runs to hundreds and hundreds of pages. There are so many different aspects in it. And if my information is right, another bench was constituted to understand what exactly is the ratio of the case. In such a scenario, you can see some of the judges said that the rule of law is a part of the basic structure of the Constitution. Free and fair elections are the basic structure of the Constitution. Some courts have come to the extent to say that all fundamental rights are basic structure of the Constitution. When you reach to that particular point, there is no difference between the decision in the Golaknath and the basic structure they are coming. So how do you differentiate between these two?
We go by what is called least possible denominator idea. It is true that in one of the judgments, freedoms of the individual, what you are saying is not fundamental rights, but freedoms of the individual. What kind of freedoms? There is no further elucidation. So therefore, do we take it as part 3 rights? Or do we take it as some of the important facets as right to life and liberty, equality, or some of these individual kind of freedoms which are sacrosanct so far as the existence of any individual is concerned? That's why I said that Keshwanand Bharati is like is a journey which one has to undertake. The moment you try to get into Keshwanand Bharati, you have to read every single judgment, find a common kind of denominator, and then say that these are considered to be the basic features of the Constitution. Or you must say that very well, this is the principle which has emanated. This is what principle emanates from the other judgments also. There appears to be a majority here. So therefore, this will be taken as basic feature of the Constitution. Do you know this? 13 judges constituted the bench. The order of the court is not even signed by 4 of them. They refused to sign on the very same ground. They said, how do you call out this as the principle emanating from the judgment? Sorry, we refuse to sign. So 4 judges actually refused to sign. Only 9 judges have signed, which means all judges in majority plus 2, Justice Palekar and Chandrachud, they signed the majority, the final order. Other 4 judges refused to sign it. That's also the same logic which is there. What you said is right, that there was an attempt when Chief Justice A.N. Ray was in the seat as Chief Justice. He did constitute a bench, but then he invited wrath of Palkhiwala to such an extent that the bench was wound up. Correct. So therefore, it is like a path of guidance. It's like, how do I put it? It's like the existence of God. Who has seen the contours of that God? Who has seen the limits of that God? Who has defined the God? Nobody. But we still know that there is something, some kind of idea that God exists. Everyone tries to define it the way he wants to do it. So it's like nirguna completely. Similarly, Keshwanand Bharti is also at that level. So therefore, everybody has to decipher what exactly would be the idea flowing from Keshwanand Bharti. And that is why, rather than Keshwanand Bharti, people now consider what are the subsequent judgments which have received what is called endorsement by the unanimity. So therefore, that becomes now the consistent voice. It is true that there is a problem like this, but we have overcome that problem.
So my question is with regard to what you just concluded, that is the future of basic structure doctrine. That particular doctrine has been used to change many things in the constitution, which we considered as unamendable, like the 370 or something like that. So what is the future? It was not mentioned directly in the constitution, but developed by the courts. So when there occurs a conflict between the parliament and the judiciary, a tug of war, something like that, what is the future? Will it help in stabilizing the constitution, or will it be taking away the stability that a parliament,
See,
a supreme parliament?
ma'am, from 73, when Keshwanand Bharti was decided, we have covered almost 52 years. Correct? So therefore, future for us began from 1973. So for last 52 years, now we are guided by what happened in the past as well. And now why this prospective overruling? You normally consider that when a judge decides and interprets the law, the interpretation of the decision must get applicable right from the moment the law was enacted. So if you say a law is void, it must be void from day one. Correct? So therefore, interpretation by a judicial organ is always retrospective in nature. Whereas every legislative instrument, unless intent is positively expressed, will always be taken to be applicable prospectively. Because you can't change the law for the citizens with retrospective effect. Constitution doesn't give that kind of idea when it comes to criminal law. So therefore, the normal principle is any legislative action will always be prospective. Every judicial interpretation will always be retrospective. But in Golaknath, they were troubled by the idea that if we say that Article 13 is your now filter, then all of those amendments can be challenged. And by this time, right from 1950 till 1967, in 17 years, generations of people have accepted certain norms in the society. Lot many agricultural holdings have been sort of taken away from zamindars. What do we do now? Therefore, they came out with the idea, just as legislation can be prospective, we will overrule it by prospection, prospective idea. That is why that prospective overruling as a principle. Correct? It was adopted in 67, but the Keshwanand Bharti said even Golaknath was wrongly decided. So therefore, one need not actually go to that level. But Keshwanand Bharti, post Keshwanand Bharti, the applicability of the doctrine of what is called basic structure is certainly applicable, and we have been guided by that. I gave you the examples. Okay.
Thank you, sir.
Thank you. Thank you. I enjoyed this. Thank you.
As we conclude this memorable session, I invite the academic advisor, coordinator of Dr. N.R. Mathaman and Chair on Legal Education, Dr. P.G. Thomas Kutty, to deliver the vote of thanks. Sir, please.
Esteemed guest of the day, Honorable Justice Mr. Uday Umesh Lalit, Advocate Joseph Vanmanath, Professor John P.C., Father Adarsh Kumbalat, special invitees, faculty members, students, and distinguished attendees. It is indeed a delight and an honor for me to extend a warm vote of thanks on behalf of Mgr Gregorios College of Law and Professor N.R. Mathaman, Chair for Legal Education, for the illuminating lecture by Justice Uday Umesh Lalit on Challenges to the Constitution of India, Perspectives and Prospects. This discourse was truly a befitting tribute to the Most Reverend Dr. Benedict Mgr Gregorios of revered memory. Your Excellency, your wealth of knowledge, profound insights, and unmatched experience in the realm of constitutional law have enriched us today. Your analysis reminded us of the resilience and adaptability of our Constitution while underscoring the collective responsibility we bear as citizens and scholars to uphold its principles. I would like to express our deepest gratitude to Honorable Justice Uday Umesh Lalit for taking time from his busy schedule to address us. Your words has left an indelible impression, particularly on younger minds present here, who will undoubtedly carry forward the spirit of constitutional values in their professional and personal lives. Sir, kindly accept our humble thanks. On behalf of N.R. Mathomenon, Chair on Legal Education, I would like to extend my indebtedness and gratitude to Advocate Father Joseph Vanmanath for his priceless support in organizing this lecture. Thank you, dear Father. I extend formal thanks to my beloved Principal, Dr. P.C. John, Reverend Father Adarsh Kumbalathur Bassar, my good friend and Vice Principal, Professor V. Ramchandran, special invitees, faculty members, auxiliary staff, student volunteers, guests for their involvement in this program. It is my duty to acknowledge the support and skillful management of Professor Ria Susan John, my co-coordinator of the chair. Thank you, teacher. Finally, I wish to thank our audience whose engagement and enthusiasm have made this event all the more meaningful. Once again, sincere thanks to one and all. May God bless us. Thank you all. Jai Hind.
I believe that today's discussion enriches your understanding of the topic, Supreme Court and constitutional amendments. As learners of law, we must continuously hone our expertise in service to the public, and this discussion may serve as a vital instrument in that endeavor. Thank you. I request everyone to rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
The meeting is formally dispersed.